number 74, Xrel Johnson versus Superintendent Council.
Good afternoon, Your Honors. My name is Denise Fabiano, and I represent the petitioner appellant, Fred Johnson. And I'd also like to reserve 1 minute for rebuttal, please.
1 minute?
Yes. So in this case, the state is claiming the absolute authority to hold an indigent person who's been granted parole in prison for the rest of his life, simply because he can't afford a private SARA-compliant address that's not within 1,000 feet of a school. That's the absolute authority that the state's claiming here, and that's what they're asking you to sanction.
I thought their argument was they have the authority to hold them until they find SARA-compliant housing, not forever and ever, which is what I think you are trying to argue. I understand your point that the logical extension of their analysis is that means you could hold someone up to life. But what they're really arguing is that this is a stopgap, this is otherwise what they're doing until the SARA-compliant housing is available for the individual.
Actually, I mean, their argument below and here has been that they have the authority to hold Mr. Johnson in for the duration of his sentence, which is life. We can say, yes, we'd like to take you on your good faith representation that you won't do that, but when you're balancing that against your absolute right, your right to liberty here, I don't think docs or the state, we can give them that authority, that they're going to do the right thing because they say they will.
But they did adhere, right? I mean, they released your client,
He
right?
was ultimately released to 27 months past his open parole date.
Right.
And on that point, counsel, can we just back up a little bit and address the threshold issue first? And what makes your client entitled to a writ of habeas corpus here? He's out, right?
Oh, why it's not moot? Because again, I don't think the state has contested that it's likely to repeat itself. The third department said that as well. It's whether it's going to evade review, and it will, because he's out and we're here now.
Well, but if as you say, first of all, it's 2.5 years.
Yes.
Which arguably might be enough time to reach certainly the appellate division, if not this court. And your argument is it could be much, much longer. So if that is the case, and your client did find SARA-compliant housing, but maybe the next person won't. And it seems to me that you're making a distinction between this situation and the others that we're hearing about today. And if you look at actually the times that the other people were in RTFs, it is a significant difference. So I guess to me, how can you make both arguments that it could be indefinite, but yet it will evade review?
Well, just first of all, there's something slightly reprehensible about saying that the very illegality that it allows you to hold somebody in prison for life is what's going to make it evade, not likely to evade review, to make it moot. And on top of that, the state, it would be unseemly to grant them the ability to release somebody off of the list they control, and then every single time they could avoid having to have this issue decided by this court.
If we decide it's not moot, what's the illegality you just referred to?
The illegality is, and I guess it's a substantive due process. Mr. Johnson does have a right to liberty here, and with substantive due process, it's always a balancing. There's a ledger, right? What are Mr. Johnson's interests?
Can I just clarify? Are you challenging his incarceration? Let me get this right. You're challenging his incarceration, not the statute. Is that right?
I'm sorry. Yes, correct.
You're
As
challenging
applied to Mr. Johnson,
Right.
the state's claimed right to hold him in prison for life because he didn't have a SARA-compliant address is unconstitutional.
Now let me go. So the next part of that is, what standard of review are you asking us to apply?
I'm asking for strict scrutiny because at its core,
And what if we say it's rational basis? What's your argument then?
I still don't think it meets rational basis because, again, we go back to the substantive due process ledger. We have Mr. Johnson's right to be out in the community. He has been granted parole here.
Is his liberty right a little bit weaker than, let's say, Mr. Ortiz's or Mr. McCurdy's?
I don't believe so. He's been granted parole. He's been granted the right to be out in the community. that's a significant liberty interest, right? To
Yeah, but
serve your.
parole still involves a restraint on liberty, on some liberties. So, and that's pretty clear. That's really not a
Sure.
contestable point. The contestable point seems to me the imprisonment in the absence of a violation. Isn't that what your point is?
Yes, sure. Docs
Okay.
is acting prematurely here.
So,
They're, on
go
their
ahead.
side of the ledger, right? We'll go back to the substantive process ledger. Nothing has been violated here. Their interest is intact. There is nothing, they're acting preemptively. He has not violated parole, and their interest can be achieved by releasing him to avail himself of his right to SARA-compliant shelter in New York City as a right to shelter city under the Callahan Consent Decree.
I thought there was something in the record suggesting he had violated parole.
Oh, well, since, he's
Yes.
been rearrested, Your Honor,
Yes.
since he's been out, yes.
And that's a violation of his parole as well?
Whether a parole violation drops or not is up to parole.
Thank you, counsel. Counsel?
May it please the court. This case should be dismissed as moot, but if the court reaches the merits, it should reject petitioner's substantive due process claim. I want to get right to petitioner's argument that a ruling for the state here would authorize indefinite detention for all SARA inmates seeking compliant New York City shelter housing. That is not the case, and I have about 4 limiting principles to give you. Number 1, this is somewhat of an exceptional case on its facts, and this is an as-applied challenge. Petitioner here has a trigger, a sex offending trigger that readily applies to minors, namely adolescent girls. He's triggered by the sight of women in, quote, a tight dress and tight pants. Also, petitioner's modus operandi for sex offending doesn't require the sort of physicality that greatly diminishes with age. His pattern of sex offending has been seeing women in plain sight, approaching them from behind, and rubbing up against their buttocks. Not a great physical hardship. So that's number 1, just on the
So how
facts
does
of this.
keeping him away from a school address that particular risk?
Keeping him away from a school addresses that risk because he, at least according to his own testimony at the parole hearing, there is a substantial risk that he would be triggered to sexually offend by anyone who resembles a woman in a
He
tight
does
dress.
this on the subway?
I'm sorry, Your
He
Honor?
does this on the subway?
He has done this on the subway, but his self-described...
Has he done it other than on the subway?
There's no record of him having done it other
Isn't
places.
the better condition, don't ride the subway?
I'm sorry, Your Honor?
Isn't the better condition to reduce the risk, don't ride the subway?
I suppose that would be a rational condition as well, but I think Your Honor's colloquy is pointing up the fact that the SARA restriction is working. The SARA has limited his contact with adolescents, and for example, adolescent girls that you'd find at a high school who might wear tight clothes and fit
I don't know, they ride
petitioner's trigger.
subways too, I'm not so sure about that.
I'm sorry, Your
They
Honor?
ride subways too.
Well, the SARA restriction doesn't have to do with subways, it only has to do with...
I know that.
With distance from a school, and just because it doesn't address every single issue does not mean it's irrational. It's rational if it cuts down on the chance for petitioner to reoffend.
Let me ask you this. If all the science and all the data says that this type of restriction doesn't achieve its goals, can it be rational?
Well, the science and the data doesn't say that. It certainly doesn't say that with respect to people in petitioner circumstances, people who have a trigger that is activated not by seeking out victims, stalking them, or the like.
No, I thought he said women. Did he say women?
I'm sorry, Your Honor?
Did he say women in the tight-fitting clothes?
He did say women in
Yeah,
tight-fitting.
that's not usually a child.
No, not usually a child, but the interest of SARA is not limited to children as we might think of a child of 10 or 11. It's limited, the interest of SARA, that statute is addressed to minors, anyone under the age of 18.
Yeah, we don't usually refer to a woman and equate her with a minor, is my point.
Oh, I agree with you.
But
And we-
I'd like to hear your answer on the science.
Well, my answer on the science is, and some of the articles that we cite in our brief show, that for people in, first of all, we think that would be a legislative issue. The question would be whether the legislature should revisit the wisdom of SARA or not. But the science, according to the articles we cite, show that people like petitioner would be rationally deterred by the SARA.
So your position, the science is in dispute?
I think there's some dispute about the science.
If there was not, I understand your point, of course, about the policy decision. The legislature needs that information. I'm not disputing that with you. But can the legislature really enact a law that goes against all of the science regarding the actual achievement of the goal? Isn't that something that's within our bailiwick?
If the science was that lopsided, I would be
No, not lopsided. Absolutely contrary. My hypothetical is not about science where there's some dispute, there are different, I didn't ask that question. I understand your position on that, it's a very compelling one.
Well,
If all of the science really shows otherwise,
if all of the science really...
it's like climate change.
Yeah, if all of the science really shows otherwise, I suppose there would be a strong argument that it is irrational, although I would go back to the fact that this court's cases have always said that the rational basis test and the rationality with which a legitimate interest is served can be backed up with rational speculation. So I think really at the rational basis level, aside from just an overwhelming, undisputed scientific consensus of the sort Your Honor is positing, the legislature is allowed to engage in simple rational speculation and logical thinking, if A, then B, if B, then C,
Anything
et
short
cetera.
of that, anything short of that allows the legislature, of course, to act and then would survive rational review, rational basis review.
I think that's right. And I do want to address some of the other reasons why a ruling for the state here would not sanction the indefinite detention that petitioner raises the specter
I'm
of.
particularly
Before you do that,
concerned, go ahead, Judge, I'm sorry, you finish.
A slightly different question, talking about whether we're talking about rational review or some other rational basis review or some other standard. Can there ever be a fundamental right that is based on a statutory or regulatory scheme as opposed to a constitutional right?
Our position is no. Our position is that not all constitutional rights are fundamental, but all fundamental rights do derive from the Constitution.
And where was the right being claimed here derived from in your view?
Well, it's not only my view, it's also the view of the prominent Second Circuit case that my friend on the other side cites, the Victory case. The right here derives from New York State's legislative and executive parole scheme. As a constitutional matter, there is no fundamental right to release while subject to a valid prison sentence. And as petitioner pointed out, he remains subject to that valid prison sentence. It is a long sentence, it's a life sentence, but strictly speaking, that sentence authorizes imprisonment up to the maximum, up to life. But there are good reasons to think that that sort of life imprisonment for failure to satisfy the SARA condition would not apply. And I think I tried to discuss one of them, which is the particular facts of this case, but there are also mechanisms available to the offender to try to extricate himself from the SARA law. Number one, the sex offender can petition to modify his level 3 designation. All the arguments being made on the other side today about why, notwithstanding petitioner's level 3 designation, he's simply not that guy anymore, he's reformed, etc., he's aged a little bit. Those are all excellent arguments to be pitched.
Well, but that hasn't really been the case in this case, has it?
No, exactly. But what I'm saying is there are avenues open to offenders to take steps to ensure that SARA does not apply indefinitely. So they can try to modify their designation. And if the evidence is as persuasive as my friend on the other side says it is, then that modification petition would be taken seriously.
He was kept in Adirondack, right?
That was the facility from which he was discharged.
Was that a residential treatment facility?
No, that was not. That was
How long was he
correctional
kept
custody.
there?
I'm sorry, Your Honor?
How long was he kept there?
I'm not sure how long. He was kept in correctional custody for 27 months. I'm not sure the percentage of that was at Adirondack.
I guess my question is, was Adirondack used as an RTF?
No, and my answer was no. No, it is not. It is correctional custody. And the reason he was in correctional custody is because he had a parole sentence. He still was subject to a valid...
After someone's been placed on parole, can the 6-month limitation ever kick in for someone who has a lifetime sentence?
Well, as I understand it, the 6-month limitation is more geared towards folks on PRS serving definite terms. I don't think that issue has really been brought up in the parole indefinite, indeterminate term context. So I think the the statutory framework would be a little different. I do want to get to just a couple more of these limiting principles because the other side's argument
Go ahead.
really does seem to be that a ruling for the state here would authorize indefinite detention. So in addition to seeking to modify their level 3 designation, which for a petitioner like Johnson would get him out of SARA, the sex offender might sometimes have avenues on direct review and thereafter to try to reduce their actual penal sentence. And of course, that would directly reduce the amount of time that they are within DOCS's jurisdiction and SARA would apply. And also this court, I suppose in theory, has another mechanism available to it to police these sorts of situations as well. I could imagine that there would always remain the judicial backstop of review for government conduct that shocks the conscience, even outside of the sort of rationality of continued applicability of a legislative act that would implicate the standard rational basis review. So if there are no further questions,
Thank you, counsel.
we would ask that you affirm. Thank you.
Thank you. Ms. Fabiano?
Just to pick up on a couple of threads there. First of all, Mr. Johnson was held in prison. He was in a correctional facility. There was never even any pretense of transferring him to an RTF at all times. He was in prison.
He was never in an RTF.
Never. And that's because DOCS claims the authority. That's the only way they felt they could keep him was because they felt he was within his life sentence. They had the authority to keep him in prison pursuant to that life sentence. Picking up quickly on Justice Rivera, your line of does the science support, what does it support? I think our brief lays out fairly well, as does the third department's concurrence, that the efficacy of these restrictions is really, it's greatly in question. It's not even in question. It shows that it's just not, it doesn't achieve the goals that they want to achieve. But aside from
Why
that, even
isn't
as
he
a,
right that really is for the legislature?
yeah, well, I can move on to Mr. Johnson. As applied to Mr. Johnson, he doesn't have a child victim. He's never had a child victim. His cases up until this point have been women on the subway.
But isn't the point that, how do you distinguish between a mature 17-year-old and a 19-year-old woman? I mean, so isn't there still this significant risk that his particular
Well, I guess it's not locale restricted, I guess I would say. Whether he's on the subway,
does
you're
the
around.
restriction have to cover all possible risks?
I'm sorry?
Does the restriction have to cover all possible risks in order to be rational?
No, but again, as applied to Mr. Johnson, there's nothing to indicate that it's always been a woman on the subway. There's 4 or 5 cases. But aside from that, again, we go back to he's been granted parole. And the state can achieve its goal here by releasing him. They can achieve its goal, just as they did when they released him this time.
Okay, but your point about,
he's entitled-
if I can interrupt you here, this point now about parole, I get the bigger point about parole, is that the Board of Parole has already determined his risk and determined it's appropriate with conditions in place to release him?
Mm-hmm.
Is that yes or no? That's yes or no?
I'm
Is
sorry,
that- I just want to know if that's your position on that.
that the board can determine his risk.
Not that they can, that they have already made this assessment
They've
about
made
risk.
this-
Is that your point with this line of
They've
argument?
made their assessment.
Okay, so why aren't they right, because I believe this is what they had in their brief, that included an understanding, of course, that he would have to comply with SARA, and if he doesn't have compliant housing, that he's not going to be out.
Well, because there's nothing to say. Imposing the condition doesn't give them the right to hold him in prison in anticipation of what they believe is going to be a violation. There's nothing in SARA to give them the right. They can impose conditions. Just like they could say, you've got to go to this drug program when you get out. Fine, I'll sign off on that. If he doesn't go when he's out, then they violate him and they bring him back in, or they do what they will with him.
So your approach to this is, he's got parole, gotta let him out. If he doesn't have SARA compliant housing, then he's violated parole.
Well, there's a number of...
Where's the victory in that?
Well, I don't think that's because I don't think that's actually how it would play out. He's entitled to shelter.
Yeah.
And he's entitled to SARA compliant shelter in New York City. And that's what he would go avail himself of. That's what he requested, and that's what he has the right to do. But even so, as my colleague had mentioned, DOCS determines and decides how and when and if they're going to enforce any of their conditions. They don't drop a parole warrant every single time you have a dirty urine or whatever it is. You have a curfew violation. They make reasonable decisions about these
Yeah,
things.
but that's, that is episodic, as opposed to you don't have a place to live that is in compliance with this particular legislative mandatory condition.
It's a condition, it's not a bar to release, but they can, he
condition
can
proceeding.
comply. He can comply. He can comply with the shelter system.
Okay,
And
okay.
I would just point out there was a case I cited that came out in September in the Second Department, Kahn versus Annucci, and that sort of will give you a glimpse of what DOCS does. There was somebody who was already out in the community, and a school opened up near him. They gave him time. They were reasonable. So you could put them in temporary housing like that, and then when a SARA-compliant bed opens up, he gets it. And even in Kahn versus Annucci, they allowed him...
Is there anything in the record to indicate that there are enough SARA-compliant beds in the shelter system to accommodate all of the people being released under this condition?
I think all we have to go on in the record is the fact that that the Callahan consent decree exists, that the city will provide a shelter bed to whoever requests one, and that but the Bonilla court specifically found that DHS agreed and was ready, willing, and able to comply with that. When the Attorney General asked on cross-examination, what if, everybody came?
But that's assuming we accept and don't grant the motion to strike
So
that testimony.
I'm sorry, the Bonilla decision actually sets forth everything that we need to rely on anyway.
Okay.
The Bonilla decision says that the DHS recognizes its obligation and indicated that it would find a bed for anyone even if there were no vacancies.
Thank you, counsel.